This employment law video is on mental health. Employers have various duties in relation to the mental health of their employees. Health and safety. Under health and safety law, there is a general duty on employers, as far as reasonably practicable, to ensure the health and safety and welfare of all of their employees at work. And this applies to mental health and physical health. Health and safety regulations also require employers to make health and safety assessments in the workplace. This should include risk assessments on matters such as employees' workloads and stress levels. The legislation imposes criminal liability for breaches. Unfair dismissal. Employers can dismiss fairly, provided that there's a fair reason for dismissal and that a fair process has been followed. Generally, employees who have at least 2 years' service can bring an unfair dismissal claim. Capability is a fair reason for dismissal, and a dismissal could potentially be fair on the grounds of incapability due to ill health. An employer would, however, have to follow a fair process. Some of the things that employers would need to consider would be whether sufficient medical evidence had been obtained prior to any decision to dismiss, whether there'd been any warnings, whether the employee had been given an opportunity to put forward their case, and whether there were any alternatives considered to dismissal. Constructive unfair dismissal may be relevant too. Disability discrimination. An employee with a mental health illness may come within the disability discrimination protection. To fall within protection, the person would have to have a physical or mental impairment which has a substantial and long-term adverse effect on their ability to carry out normal day-to-day activities. Normal day-to-day activities could include concentration or engagement. And someone, for example, with depression may have difficulties in concentrating. Where an employee is protected, the employer must not discriminate in a number of different ways. Employers must not, for example, treat an employee less favourably because of disability, or treat an employee less favourably because of something relating to a disability. There is also a duty to make reasonable adjustments so that a person with a disability is not disadvantaged in the workplace. Reasonable adjustments could include changing performance targets, altering duties, altering work times, carrying out a risk assessment, allowing time off for treatment, arranging a phased return to work, negligence cases and other claims. An employee, for example, who's been given an excessive workload or who has been bullied or harassed and suffers psychiatric injury could bring a negligence claim in the courts. These cases, though, are often difficult to bring because the type of injury has to be reasonably foreseeable. Also, under the protection from harassment legislation, an employee may bring a claim where there's a course of conduct amounting to harassment. Here are some steps that employers should consider taking. Fostering an open culture where staff are not afraid to speak out about mental health issues. Showing strong leadership on mental health issues. Maintaining up-to-date policies on bullying, harassment, ill health and equal opportunities which are regularly communicated to staff. Offering mentorship and counselling services. Training managers on mental health and how to support staff. Offering flexible working. Encouraging staff to take proper breaks at lunchtime. Encouraging staff to take their full holiday entitlement. And carrying out risk assessments to ensure employees are coping with their work. That's my video on mental health. The usual caveat is that this video is for guidance only and should not be relied upon for specific advice. For more information, do visit my website. And if you're interested in receiving notifications on other employment law videos, do subscribe to my channel.